Well, all right. We will begin the Incarceration Prevention Reduction Task Force meeting, also the Law and Justice Council meeting for December 15th. And we're calling this to order, and I'm going to read the land acknowledgement now. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that brings us together here today. And please join us in uncovering such truths at any and all public events. All right, and with that, I'm going to turn things over to Raylene to introduce our presenter.
Thank you. Raylene King, Markham County Superior Court County Clerk. It is my pleasure. It is my pleasure to introduce Judge Brandon Johnson of Walla Walla County Superior Court. In addition to his work on the bench, Judge Johnson is appointed to the Washington Court's Fire Brigade, formerly known as the Bench Bar Press Liaison Committee. This group is made up of judges, attorneys, and members of the media who work collaboratively to address and resolve issues at the intersection of fair trial rights, a free press, and open courts. The Fire Brigade serves as a resource and troubleshooting body, helping guide judges and journalists through matters involving court access, media coverage, camera, and recording in courtrooms, always with the goal of maintaining transparency while protecting the integrity and fairness of the judicial process. Last year, I had the opportunity to attend one of the Fire Brigade trainings where Judge Johnson presented on bail, and his insight and clarity on the topic were invaluable. We are fortunate to have him with us today to guide us through why bail exists and how it works within our justice system. Please join me in welcoming Judge Brandon Johnson.
Thank you. Thank you very much, Ms. King. I appreciate the opportunity to be here this morning. I am one of two Superior Court judges in Walla Walla County, and as a result of that, we alternate what we call presiding weeks, where we handle all dockets. So every other week, I do make pretrial release decisions for anyone arrested on felonies during that week. Pretrial release decisions are some of the most difficult and also most common decisions a superior court is called on to make. A common question I receive is, why, if a person has been arrested on a law enforcement's finding of probable cause, and if a judicial officer has also found probable cause exists, why is that person being released without having to post bail? And the first starting point to answer that question is our state constitution. The Constitution includes a presumption of innocence. And it is important to recognize that these pretrial decisions are just that. They're pretrial. They're pre-adjudication. This is an accusation only. And the standard, the probable cause standard, is a much more relaxed standard than the finding of beyond a reasonable doubt necessary to convict someone of a crime. That constitutional presumption is incorporated into the rule that governs pretrial decisions, which is Criminal Rule 3.2. That rule requires us as judicial officers to consider all less restrictive conditions before imposing bail. So stated plainly, bail is the last resort. It is not the starting point. And why is that important? The Court of Appeals in a case called State versus Huckins from 2018 tells us that the purpose of the bail rule is to alleviate the hardships associated with pretrial detention and bail. And what are those hardships? Number one, defendants are handicapped in preparing their defenses. It's more difficult to meet with your attorney if you're in jail and are relying on the capability of staff and staffing issues to get you into an interview room. It's more difficult to help assist your attorney in the investigation. That might be producing pay stubs or some other indication that might prove a defense to the accusation. Defendants who are detained are unable to retain their jobs and support their families. The hardship there is evident. You could find yourself not only being charged with a crime, but now losing your apartment or because you can't pay your rent. Clearly a hardship. The stigma of incarceration before being convicted. Again, this is a pretrial decision. The person's been accused, but they've been convicted of no crime, yet they're housed in a county jail, typically with a part of the population, of course, are going to be people who are post-adjudication, whether they've entered a guilty plea or been found guilty by a jury. And then defendants suffer incarceration because they cannot afford bail, poverty. We get into the haves versus the have-nots. Because of those hardships, the starting point under Rule 3.2 is release without conditions, any conditions, not just bail. The starting point for the rule, the presumption is in non-capital cases, a person's been accused of a crime, their first appearance is telling them what they've been charged with, or excuse me, they haven't been charged yet, typically. Sometimes, depends if it's a probable cause arrest, but if it's a probable cause arrest, this is what you were arrested for. This is the maximum penalty for the crimes, and here's your next court date. Please come back to court. If we want to impose conditions, there are two primary categories or buckets under which the court can impose conditions. And again, this is any condition, not just bail. So the first category is future appearance. If the court is concerned, I don't think you're going to come back to court when I ask you to come back to court. That's one category. The other category is a likely danger to commit a violent crime, intimidate witnesses, and or unlawfully interfere with the administration of justice. Turning first to the failure to appear concerns. The rule gives us relevant factors to look at, and this is a non-exhaustive list, so it's including but not limited to. So the first one is a history of responses to legal process, particularly court orders to personally appear. And this is the old maxim that often the best indicator of future performance is past performance. So a person who has a history of not coming to court and has a laundry list of failures to appear can certainly cause the court concerns. What is the person's employment or educational status and history? Do they have a job? Are they going to that job every day? Are they in school where they're going to classes frequently? Are they involved in counseling where they meet with a counselor on a frequent, regular basis? What are the person's family ties and relationships? The person's reputation, character, and mental condition. That can be tough because on a first appearance, you often don't know a lot about the person who is appearing before you. Length of residence in the community can be a big one. A court's going to have, or I'm going to have fewer concerns with somebody who's lived in the Walla Walla Valley for 20 years than I am somebody who got to town, 2 weeks ago or was passing through. The person's criminal record is also a factor the court can look at. Community vouching by a responsible community member for either the person's reliability or, in my opinion, more importantly, to assist the accused in complying with conditions of release. So if we have a person who has been unable to get to court in the past, and that's causing the court concerns now, and let's say they've lost their driver's license, if a sibling or a coworker or a parent or someone comes forward and says, I understand this person needs to get to court, I will drive him or her, that can be a relevant factor for the court. The nature of the charge, if it's relevant to the risk of non-appearance. So the nature, we'll talk about nature of the charge on the community safety side, but on the failure to appear side, if you're going to look at the nature of this charge, it has to be relevant to the risk of non-appearance. So what might that look like? Well, if the accusation is attempting to elude, that could cause concerns. If the allegation is escape, that could cause concerns. And then there's a catch-all of any other factors indicating ties to the community. I recently had a case where the accused was a foreign national who had been subject to removal proceedings years before and then re-entered. Now, having been subject to removal proceedings is not on the list, but that's certainly something that the state wanted to argue about a likelihood to appear in the future. So evaluating those factors, if the court determines I have concerns whether this person is going to come back to court, I would like to impose conditions, then the rule tells us must apply the least restrictive conditions, one or a combination, to secure that person coming back to court. And the rule gives us examples of what we might do. We could place the person in the custody of a designated person or organization agreeing to supervise the accused. This could be family. I get a lot of moms and dads who come in and say, hey, I'm going to make sure this person gets to court. It could be a nonprofit. Here in Walla Walla, we have the Christian Aid Center, has programs, and they have rules with curfews and things like that. So they might say, you know, Bob is going to stay with us and he's going to be in this program and be subject to these rules. The court can place restrictions on the person's travel, association, or place of abode during the period of pretrial release. We can require the accused to return to custody during specified hours, which is day release. We don't do that in Walla Walla. I have been told that and it makes sense to me, is really hard on corrections and our local jail when you have people who are checking in and out on a regular basis for contraband concerns. So that's not something that we do here. Electronic monitoring, an ankle monitor, if available. And the rule specifically says if available. That's a resource that is certainly not unlimited. Walla Walla has been fortunate. We're involved in a pilot program right now with APPR, and I've learned that nationwide, the empirical evidence, and I try to make decisions based on empirical evidence, the empirical evidence would suggest placing a person on an ankle monitor does not have an appreciable impact on them coming back to court, which I thought was the most counterintuitive statement. I had to ask, really? But that's what the stats show, that it doesn't really help people come back to court. And then there's a catch-all: impose any condition other than detention. And again, that's from the rule, other than detention deemed reasonably necessary to assure appearance as required. Then, after considering all of those, if the court is satisfied none of those conditions individually or in combination is going to secure this person coming back to court, then you can consider bail. Only then. And then when you get to that bail determination, you must consider the accused's financial resources for the purposes of setting a bond that will reasonably assure the accused's appearance. What does that mean? Does that mean that you set the bail lower for a person who's in poverty, or does that mean that you set it higher for someone who has substantial resources, like speeding tickets in Finland or Denmark or wherever it is I read about? Or is it both? And that, of course, then the question, well, is there a normal bail? I mean, what do you use, the federal guidelines? These are difficult questions. I think it's all has to be done on a case-by-case basis. So that's the failure to appear side of the rule. The other side of the rule is the community safety side. And here I'm going to read some of the language because I think it's interesting in subsection E versus what's earlier in the rule. So what it says is relevant factors showing of substantial danger in determining which conditions of release will reasonably assure the accused's non-interference with the administration of justice and reduce danger to others or the community. The court shall, on the available information, consider the relevant facts, including but not limited to. So again, non-exhaustive. The reason I point that out is earlier in the rule, it talks about violent offenses. The phrase is likely to commit a violent crime. But it also goes on to say that violent offenses are not limited to those defined by statute. And it's RCW 994A030. But here in the rule, it says reduce danger to others in the community, which certainly sounds more broad. So does that include a possession with intent to deliver offense? Is there a difference between someone accused of possession with intent to deliver fentanyl powder versus psilocybin? Should there be a difference? Should the court get into the weeds on that level? What about attempting to elude? Certainly, attempting to elude can be a danger to the community. There's a reason law enforcement will stop a pursuit because they're worried about that impact on the community and community safety. But eluding is not a violent offense, and it's not an administration of justice issue. What about a person who is a serial recipient of burglary in the second degree charges because he or she has been trespassed from Walmart, but cannot seem to stop going to Walmart and allegedly stealing? That's a felony because they've been previously trespassed. What if they always come to court? So if you don't have failure to appear concerns, is burglary 2 for repeated Walmart shoplifting? Is that a violent offense? Is that a community safety? Does that mean under the rule that he or she should always be released as long as they come back to court? That revolving door that people often talk about. These are tough questions that the court has to wrestle with all the time. So then the court looks at factors, again, similar to the failure to appear on this side of things. What do we look at? We look at the person's criminal record. Do they have a history of violent offenses? That's going to be very impactful as to whether the court is concerned about committing a new violent offense. Community vouching, same language as on the failure to appear. Is someone, family member, coworker, somebody going to come forward and say, hey, this really, Bob really is a good person. I don't know what happened here. Again, in my opinion, more importantly, I'm going to help them. Maybe there's no alcohol in my house. There's no weapons in my house. I'm going to make sure they get to court and I've got rules. You look at the nature of the charge. It's not specific here like it is on the failure to appear. In general, how serious is the charge? The person's reputation, character, mental condition, past record of threats to victims or witnesses, or of interference with witnesses or victims. Evidence of present threats. Sometimes a probable cause affidavit will include the accused making direct threats of intimidation to witnesses. The court's certainly going to be interested in that. A past record of committing offenses while under conditions. And this occurs sadly quite frequently and is definitely something the court looks at. Are you accused and law enforcement and the court has found probable cause while you're already on a pretrial release order, or while you're post adjudication and already and you're on DOC custody? And then threatened use of deadly weapons or firearms, both currently or in the past. So again, you go through that analysis. I have found factors, the court has found factors that give me concerns that this person may commit a violent crime, is a danger to the community. What can the court do? The court can do a combination of things. Who you can have contact with, that can be individuals or a class of persons. Where the person can go, where they can live. You can put restrictions on using, possessing dangerous weapons or firearms. If there's a nexus in the probable cause, you can put a prohibition on intoxicating liquors or drugs, anything that's not prescribed by a physician. A requirement to report regularly and remain under the supervision of an officer of the court or other person or agency. We routinely will require someone to check in with their appointed attorney at least once a week, or report to court services, and then continue to report to court services on a schedule they determine. We will frequently give quite a bit of discretion to court services, both in terms of how frequently and the method. Sometimes they want to see eyeballs. Sometimes they're happy with a phone call. And we try to give them some discretion there. No new violations of criminal law, which is kind of an oxymoron. Aren't we all under a prohibition on committing new violations of criminal law? But we put that in there. Custody of a designated person or organization. Again, that's the same language as on the failure to appear side. The day release, which again, we don't do, or electronic monitoring, or another catch-all, any condition other than detention. And again, the rule specifically says other than detention to assure non-interference or reduce danger to others in the community. So then you get to bail. And here the wording's a little bit different, but this language is specific on the community safety side. Quote, this condition may be imposed only if no less restrictive condition or combination of conditions would reasonably assure the safety of the community. And it has the same requirement to consider the defendant's financial resources. So again, the rule makes very clear this is a last resort. On that topic of financial resources, we will sometimes allow a 10% posting. So typically, if I set bail for Bob for $100,000, if Bob has $100,000, he can post that in cash. If Bob doesn't have $100,000, then he has to contact a bail bond company. He will pay a fee, typically of 10%. Then the bond company will post the remaining, amount. But that's a fee. That's cost. They're not going to get Bob or Bob's family doesn't get that money back. So we will frequently, very frequently for me, allow a 10% posting with the clerk. And this is really, in my opinion, a recognition that a person's financial situation, and let's be honest, how financially well off his or her grandparents or parents or siblings or uncle or aunt or whoever it might be, does that really have a bearing with the person's future appearance or community safety? And do we want to treat people differently based on the financial wherewithal of their family? I've had defense attorneys will make the argument that when a family member believes that he or she can get that money back that they've posted, that's an additional incentive on the accused. Hey, I want grandma to get her $10,000 back, so I'm going to come to court on time. As opposed to, well, that $10,000 is gone. The bond company has that, so I have less incentive. On the other side of the coin, everyone remembers the show Dog the Bounty Hunter. Having an extrajudicial agency out there with an incentive to make sure that Bob comes to court can also be helpful in making sure that Bob comes back. So the bottom line is the rule is very clear. Bail is the last resort. Couple of other quick points before I turn it over to any questions. The rule allows delay of a first appearance for up to 24 hours based on intoxication if there's a concern for the accused's safety or the safety of others, or if you have mental health concerns such that you want to have crisis come in and do an evaluation for potential involuntary commitment. The rule gives you a 24-hour window. So when you have somebody on the bench who is not there or is still coming down or whatever the case may be, you can call timeout as the judge and say, I think we should try this tomorrow. And that's something that I will use without apology. The rule does say it's limited to that 24-hour block. If after 24 hours you're going to impose conditions, you have to do it pursuant to the rule based on failure to appear or community safety as discussed before. The rule also allows for amendment or revocation of an order on change of circumstances, new information, or showing of good cause. The court can amend the order to impose additional or different conditions for release. This was a bigger deal until very recently. Earlier this year, our state Supreme Court changed our arraignment rule under Criminal Rule 4.1 and did two things. One, it dramatically shortened the period of time between filing the information and arraignment, went from 14 days down to 3 days, but it also added a sentence, quote, at the time of the arraignment, the defendant shall have an opportunity to argue bail and other conditions of release pursuant to Rule 3.2. So now we've added a second arraignment docket. We now have we do arraignments on Mondays and on Thursdays. So a person who has a first appearance on Monday before this rule, their arraignment was going to be 2 weeks later. And if defense counsel made the argument, the court imposed conditions or set bail, barring a substantial, a new change, new information, has come to light or a change in circumstances, you were going to be under those conditions until arraignment. Now we're going to set you for arraignment on Thursday, and the rule specifically says counsel's going to have an opportunity to readdress those conditions of release. The rule also allows for revocation if you have willful violations of the condition. And then the last thing I'll say, the court can, in very limited circumstances, hold a person without bail at all. The reason it's so limited is it's constitutional. Article 1, Section 20 says all persons charged with crime shall be bailable by sufficient sureties, except for capital offenses when the proof is evident or the presumption great. Now, we don't have capital offenses anymore in the great state of Washington. So when can you hold someone? The Constitution goes on to say bail may be denied for offenses punishable by the possibility of life in prison upon a showing by clear and convincing evidence of a propensity for violence that creates a substantial likelihood of danger to the community or any persons. So if you want to hold somebody without bail, it's a twofold test. One, they have to be charged with a Class A felony. All Class A felonies have a maximum penalty of life in prison. And two, you need clear and convincing evidence of a propensity for violence that creates that likelihood of danger to the community or persons. And that's going to be beyond your standard community safety. I'm going to impose bail. By the way, clear and convincing evidence exists when the evidence shows the ultimate fact at issue to be highly probable. So we're above that standard probable cause type setting or preponderance type setting. Okay, that is a primer on what courts have to do when making pretrial release decisions, and I am happy to try to answer any questions if there are any.
Thank you, Judge Johnson. What questions do we have from the gathered here?
Typically, oh, go ahead.
Heather, go ahead.
I had a few things I wanted to say before we get to questions, but Tasha, I really want to hear what you have to say too. So I would love for you to go first.
The question I have is how much, I know like you're making rapid decisions with the person in front of you. How much access to information do you have concerning all these factors? Obviously on regular offenders, you're going to have a longer docket of information, but specifically to financial, I mean, how are you going to have access to that information?
Financial typically is going to come from the accused. We do have a financial declaration that he or she can fill out ahead of the hearing. We this year changed our first appearance calendar and moved it. We used to do it at 8:45 in the morning. We moved it to 1:30, mostly for exactly what you just said, to give everyone an opportunity to gather more information, the state, the court. And, you know, the hope is the appointed attorney is going to have an opportunity to maybe even go meet with that person prior to the hearing to make it more meaningful. So as judicial officers, we have access to JABS. So part of my normal operating procedure is I will look that person up. That gives me state history. I do not have NCIS. So I don't have out-of-state history. I rely on the state to tell me if a person has criminal history from Oregon or failures to appear in Oregon or Idaho or wherever, kind of a deal. We also, part of that pilot program is a pretrial assessment that is being done by our court services person. And it's been reduced to a one-page. It would take me longer to try to explain, but it gives some percentages on failure to appear in community safety, and then it has 9 questions. And some of those are, you know, have you had FTAs in the last 2 years? Is the person over 23? And these are all based on that research, that nationwide research on what are the real relevant factors that go into it. And this kind of goes beyond your question, but the bigger picture here is, what is a successful pretrial release order? And what they will tell you, they being the nationwide experts, a successful pretrial release is one where the person comes to court when they're told and is not accused of committing new crimes. So they don't get rearrested on new crimes. We have had a tendency in our county, and I don't think it's just us. I don't think it's just our state. I think it's nationwide, to impose all these conditions on people and set them up for technical violations. And the example I use is, I'll keep picking on Bob. If Bob is a substance use disorder and uses methamphetamine, By the time Bob gets to me and is accused of a felony, I can assure you that Bob's family, friends, coworkers, loved ones have encouraged Bob to stop using methamphetamine. And yet he has been unable to do that. The idea that I, with my costume and my magic pen, what delusions of grandeur do I have to think, well, all these other people have encouraged Bob not to use methamphetamine, but now I'm going to sign an order that says, and I'm going to wag my finger at Bob and say, Bob, you better not use methamphetamine, so I'm going to subject you to UAs. And now when he can't pass his UA, he's in violation of his pretrial release order, and the state notes him up for a bench warrant, and now it gets signed, and now he's been rearrested and he's back before the court. Is that really part of a successful pretrial release? So we're in the process of kind of a wholesale look on what is a successful pretrial release. How do we define that? How do we do that in a way that tries to ensure community safety at the same time not setting people up for technical violations?
Heather, go ahead.
Good morning. Thank you so much for joining us, Judge Johnson, and thank you, Raylene, for inviting. I appreciate the grounding in the rules of Court Rule 3.2 and how bail is set. The Incarceration Task Force is a body that's been meeting for many years and is charged with how do we safely reduce and prevent incarceration in Whatcom County. And I really appreciate this window into the court system and how we can partner with our judges and support in this moment of, I think, really high leverage for incarceration prevention and reduction. I was just doing some math. And so in Whatcom County, I think we spend around $100 million annually on our criminal justice system. And we have about 4,000 jail bookings per year. And when you do the math of the cost per just bail hearing, you get to around $34,000 per person. And just for each bail hearing, it's about $500 to $1,000 in system cost, or $2.5 to $5 million a year just for the moment of deciding release conditions. And what I'm hearing in the Court Rule 3.2, the factors that are really important are safety to the community and risk, and failure to appear. How likely is somebody going to show up? And I think the safety piece is, pretty clear. We want people who aren't safe to stay, but the failure to appear, I feel like there's a lot of opportunity from the Incarceration Task Force side to support the courts with the infrastructure of pretrial services and reminders and transportation. Because when you see people continuing to fail to appear, often that's also a system issue. It's not just an individual issue. It's like the system has failed them. Why would they show up again? And I know we have a pretrial services unit here in Whatcom County. I think last I looked, I could be totally wrong. Executive's office can correct me, but I think we spend around $300,000 a year on that budget. I would love for our task force, whether it's in Raylene's committee or in a working group, to think about what are the court reforms that we could be supporting. And since we have Judge Jones here and we have your expertise, Judge Johnson, I'd love to ask, what would you need from the rest of the system? What would be helpful from the task force, whether it's data or services or policy changes, to feel more confident using those non-custodial conditions consistently?
One thing I'll touch on is anybody who has made a dentist appointment recently knows how many reminders you get, right? You get the email 2 weeks before, you get another one, and then you get the text messages, right up there. And Ms. Nixon, I don't know if she's on here, but she did a great job with that. Yep, there she is. With me, I got a reminder yesterday by email. I got another one an hour before today. And at some point you're like, yeah, I get it. Quit telling me I have this appointment. But there's a reason why dentists do that, because it works. And courts that have implemented text message reminders find that it works. I think we need to recognize where we are in technology, right? If you're calling people's home phone and sending, mail, how do we incorporate a recognition that people are on social media, and how do we get reminders to people, whether it's through Facebook or Instagram. I'm not a social media person, so whatever they might be, or just text messages. So court services, making sure that people have working phones. Do they have minutes on their phone? What apps can be used? I think adopting technology would go a long way toward solving some of those gaps, particularly on the failure to appear side. I hate to do it, but my bell rang, which means my jury panel is waiting for me, and I need to go start this jury trial. So thank you again for the opportunity. I think it's awesome that you guys have this task force. That's fantastic. I will tell you that I frequently say Whatcom County is what we should all aspire to do, the way you have your Office of Public Defense and your prosecutor's office. And I hope someday that we will march Walla Walla closer to be in line with what you folks have set up. So happy Monday, everybody. Have a wonderful day. Thank you again for the opportunity. I've got to get out of here.
Thank you, Judge Johnson.
Take care.
We have just a few more minutes for this topic. Raylene, would you like to go first, and then Executive Sidhu?
Thank you. So I wanted to say thank you to Judge Johnson for his presentation today and his time to share his perspective with the task force. Earlier this year, I provided a presentation to the Legal and Justice Subcommittee that included Judge Jones and Commissioner Emmerich on how Whatcom County currently processes bail. That presentation outlined the legal framework, constitutional considerations, and practical applications of bail decisions in our court. And the one thing that Judge Johnson spoke about is the changing of the rule on arraignments, and Whatcom County actually does now do the arraignments at first appearances. So that is one thing that is a little bit different than Walla Walla. But I think it's important to hear from Judge Jones and others in the Legal and Justice Subcommittee that deal with those decisions on a daily basis and contribute to the judges and commissioners' decisions on the bench. So thank you.
Thank you. And Executive Sidhu, please go ahead.
Yes. Good morning, everybody. And Heather, thanks for your quick math. I think the numbers are staggering when we look at these things. But one thing I just wanted to add was that when we increase our services prior to arrest or prior to reforms and prior to all those things, they come on top of the legal system. There's no way, or I don't see any pathway that this $34,000 or $100 million will get reduced by any amount if we increase those services. The example is that now it's been more than 2 years. We have started alternate response team, GRACE, LEAD, all these things. They are great programs and they do make a difference. But if you ask the sheriff's office, that has it impacted your workload, and can we take $100,000 out of your budget and give it to them? No way. So I think that's another thing we are facing financially. Whole nation is the way we are patching up a 100-year-old system, a patch and a patch and a patch and a patch. Nobody looks at changing things fundamentally. And until then, we run out of money, no matter what we do. So that's the conundrum we have. Thank you.
Thank you so much. And Judge Jones, I'm going to give you the last word, and then we're going to need to get on to the next topic.
All right. Thanks, Peter. And I appreciated the presentation from Judge Johnson. It's good to, it's good to realize from my perspective that there's, courts across the state are grappling with the application of the same rule. The idea to have a fair application for all people that come before the court. So it's good to hear that. There's a few things I just wanted to point out from a local perspective. One, the court rule 3.2 is changing. So the Supreme Court just authorized in the beginning part of December a change to Criminal Rule 3.2 that is meant, or at least most people expect it to mean, that decisions of judges will lead to more release, or at least the factors on what it means to interfere with the administration of justice are changing, where more specific threats or intimidation has to be present in a case rather than simply this kind of more broad conception that an individual might, reoffend or something like that. So that is meant, if we're properly analyzing that rule, it could lead to decisions being done a little differently across the state and here in Whatcom County. There's also proposed amendments to the Rule 3.2 that do the same thing with failure to appears. So those are proposed to take effect in 2026 if the Supreme Court passes those rule changes, which replaces this likelihood of failure to appear language that's kind of big and broad with more specific language of willful flight from prosecution, willful flight. So it's meant to kind of narrow our scope and hopefully really target the factors under the rule that give people concern or at least warrant bail in people in our court system's mind here. I wanted to comment real quick. I hope I'm not taking up too much time, Peter. I wanted to comment on what Heather said. I appreciate a couple things. One, we have ongoing budget authority, which I appreciate from the executive for our pretrial services division in Superior Court. We mean that division to improve, and we mean that division to be some security for judicial officers that they could assign somebody to some level of monitoring supervision through a court service office that will give us some assurance that people will come to court, people will not commit violent crimes in the community, and allow us to release people more freely into that supervision. So I think what help we need, we're struggling with, this whole process is predictive. We're trying to predict how people are going to act if they're released. And so I think data is an important part. We've all kind of recognized that, but we need some ability to kind of check our decisions against reality and improve them accordingly. So that's just a big thing. I know the task force as a whole is working on that, but that's something that pretrial services is struggling with also a bit, I think. We're also struggling with this idea. We mean our pretrial services division to be more of a case management model. So to not be antagonistic to a pretrial defendant, but to assist them with community services, getting to court, those sorts of things. Some other court systems have a more punitive model of pretrial services or a more enforcement model where you have these conditions of release and the service office is meant to monitor those conditions and violate report on violations. And so what would be more helpful between case management model and enforcement model is kind of an ongoing discussion that we're having too. So thank you. That's a lot, I know.
Oh, thank you so much for the local view on Judge Johnson's presentation. Very helpful for that context. All right, we're going to move on to the next subject, which is our 2025 year-end report. And Holly and Marty, would you like to take it away?
Hi. Good morning, everybody. The report is in your packets. I hope you've had a chance to read it. I think this is the time when we hope it will be approved. And if you have any comments, suggestions, and edits needed, this would, we can hear those now and get those made. Peter, you're muted, but I think you're trying to talk.
Are there any changes or comments from anyone on the year-end report that we should discuss at this time? And if not, I would entertain a motion to approve. Anyone?
I move to approve the annual year-end report for the task force.
Do we have a second?
Second.
We've got a motion and a second. Is there any discussion on the matter? And seeing no raised hands, we can now vote. Jill, I'm just double checking here. Do we have a quorum?
We do, yes.
Fantastic. All right. All in favor, please raise your hands, virtually or otherwise. Jill, just let us know.
I see all hands raised except for Prosecutor Ritchie. And feel free to correct me.
There it is.
There he goes. Thank you.
All right. Fantastic. And any opposed? Any abstentions? All right. The year-end report has been approved by the IPRTF. Thank you so much. Fantastic. Okay, on to the next item. Heather, are you
Yes, I'd love to introduce. We have our next item is the Legislative Priorities Work Group. Peter has a presentation and a recommendation for the IPRTF.
Oh, all right. Well, several months ago, we had a suggestion come forward that we begin a legislative work group for the IPRTF, and we created that work group, and the volunteers were Brian Estes, Scott Cortice, Dan Hamill, Riley Sweeney, and myself. And the work group really operates as an informal work of 5 citizens. While the subject of our work was presented to steering generally, we're now going to discuss it for the first time in this public meeting. The IPRTF is, as it turns out, an important voice on behavioral health and criminal justice legislation here in Whatcom County for the legislation at the state level. These priorities that we come forward with are they're offered really as support and not to constrain the legislative solutions. We got a late start in the calendar. I think in the future, we would like to, if we're going to put together a legislative priorities work group, we'd like to do it sooner. But nonetheless, we met 4 or 5 times, did the work. We started with perhaps, 8 or 9 different potential legislative priorities, and we discussed them all. What we decided was really the power of our priority setting was going to rest on greater focus than greater breadth. So we also checked in with the county from the executive's office to see what was on their mind, what their priorities were. Thus, we came to really 2 things for the next legislative session that we would like to discuss with you today and present as potential priorities for adoption by the IPRTF. And they both are regarding the 23-hour crisis center. One is regarding capital expenditure, and the other regards ongoing funding models. So, as you know, we were allocated in maybe 2 sessions ago. I'm turning to Jed here, who's in the room with me.
2023.
In 2023, and that allocation was.
And then it was boosted by a couple million in 2024.
All right. And so it's about $12 million. $11.2 million. Okay. So that while there was an allocation, there was a proviso language that limits how the funds can be applied. We've discussed that in these meetings before. It doesn't really reflect how we hope to use the facility as part of our community-based integrated behavioral health facility and behavioral care center. with a prosecutorial diversion program. So while we have the capital allocation, the CRC, the language around the CRC does not really allow for how we would like to use it here locally. So this isn't a huge ask. We're not asking for further appropriation, but it's more of a language change. And it is aligned, as far as I can tell, with best practices. So this is one of our priorities, is to push for this language change. This aligns with the executive's office and their priorities as well. Second, this is more about the funding model for the sustainable operation of the CRCs throughout the state. And as I probably know, and maybe have read about, and we've discussed here, a number of communities throughout the state of Washington have received capital appropriations for building a CRC, yet they have had trouble operating them. We have not, and as discussed, we have not really been able to move forward as some of these communities have in building it. But when they have built the CRC, they are unable to really have a good sustainable funding model that works for the provider, as I understand it. So there are a number of people working on this legislation to identify, or really to resolve the issues. Some of these outstanding issues on the topic include reimbursement adequacy, coverage for non-Medicaid clients, alignment with 988, emergency services, mobile crisis response. And so licensing and payment structures are still evolving and creating uncertainties for the counties. So what we would like to propose is, as a priority, is backing efforts from our legislative teams and those around the state to fix these issues. So those are really the two things that we come forward with for adoption as our legislative priorities. And I'd like to ask Jed, who is in the room with us here, if you have any comments, anything you'd like to say.
I just like to say I appreciate the time and effort that this group has put into this. The priorities that you have outlined here are aligned with our efforts in the executive's office, and it helps when we go down to Olympia to say that we have the support of a group like this, and it's not just the administration, but it's the community that's represented and the values that are represented through this task force. So that's what I'll say. Happy to take any questions.
Are there any questions from anyone about these two legislative priorities? I would love to have a motion to adopt these two as legislative priorities of the IPRTF.
I'll move we adopt those priorities.
Thank you, Scott. Looking for a second.
Second.
A second comes from Barry Buchanan. Any discussion? Seeing none, we'll move to a vote. And all those in favor of approval of the motion, please raise your hand. Jill, just let me know when we're there.
I see all hands raised except for Judge Jones.
I'm abstaining from the vote.
Thank you.
Yep.
All right. And any opposed? Bertie, Deborah, Eric, still have your hands up. Are you opposed to the motion? No. All right. I see no votes. We know we have one abstention. Are there any other abstentions? right. The motion passes, and we may thank you for that, everyone. I hope that's that is a beginning of something that the IPRTF can do each year. Is to and I believe that this work group is interested in following this through and being helpful. I can't assign anyone to go to Olympia during the session, but we may be asking for volunteers. It might be helpful. And so thanks so much. We'll get started in the next year a little bit earlier and bring this forward to you in a more timely manner.
Thank you, Peter.
Heather, back to you.
Yeah, the next agenda item we have is a framework around and definitions of recidivism. Peter has been doing some work to help us define recidivism. It's been coming up as a need for us to have shared understanding. So we've set aside a good 30 minutes or so, maybe 8 minutes of Peter sharing the framework as it stands, and then 20 minutes or so of questions and conversation and discussion. Does that sound okay, Peter?
Yeah, that sounds great. I think my presentation is going to be fairly short.
Okay.
Jill, would you put up on the screen the preliminary framework that we put in the packet? Just to let you know, if I'm sure it's quite clear to you all, I am only a citizen. I am not involved with the criminal justice system, and it is not really not my territory. I am a curious person and wanting to move things forward, and so I feel honestly out of my depth. However, in this subject, however, I'm putting this forward because, as the quote goes, if you can't define it, you can't measure it, and if you can't measure it, you can't manage it. And we are hopefully getting to the point where we're able to make some significant forward movement on Project 3 from the implementation plan. Collect data to measure progress towards desired outcomes and develop a data dashboard. This is one of our very top priorities, as you well know. Without a shared definition of recidivism, we're measuring different things and calling them the same result. The reason that I'm putting forward this three-pillar definition of recidivism is that we have really several things that we're talking about when and they're important to separate. Do we mean by recidivism a return to jail custody, adjudicated legal outcomes, or whether diversion programs reduce justice system involvement? And so each of these things are different, and I am concerned that without this conversation and with this level of detail around what recidivism is, how we define it, we'll be collapsing those into just one measure, and that is not going to do us much good. So the three-pillar plan, if you will, is that we have, excuse me, I'm looking through my notes here. Pillar 1 is system recidivism. Pillar 2 is a legal recidivism, and Pillar 3 is a programmatic recidivism. And I'm hoping that you've all read through this. I asked Bertie and let's see, I got comments from Bertie, Dean, Wendy on this subject. Heather looked through it. I'm hoping that you read through it here. I've tried to distill it down into a very simple format of definition, rationale, and where our data might come from now and in the future for each of these things. Now, again, this is really not my area. So many people on this call are within the criminal justice system and may well have thoughts and opinions and such. So I took the comments that I got over the weekend. I was able to do a kind of an update to this, and um, I'm ready to move us forward in this conversation, looking for any comments you have, and then we can produce something, hopefully over the next few months, that the IPRTF can approve very well thought out recidivism measures. So with that, I'd love to get any comments you have. Raylene, please go ahead.
Thank you. I think as we're looking at the definition of recidivism, we have to go back to, I think it was the Legal and Justice Committee where Stark mentioned defining diversion. And if we're looking at diversion, is diversion when the individual is still pretrial and they haven't actually been charged and they're looking at programs for like deferred prosecution? Or are we looking at diversion where there's been charges and they enter mental health court or drug court and then there's reoffense after that? So I think we need to look at stuff where they're not being charged in comparison to being charged.
That's great, Raylene. Thank you. It's not a coincidence that we are lining up these conversations in the way that we have. Last month, we talked about diversions. I think the one of our committees or a work group needs to be formed to take on these definitions, including the one you're talking about. Maya, please go ahead.
I just wanted to respond to Raylene and say we talked a little bit about using the term deflection as a term that could be used for pre-charging, and diversion as a term that could be used once someone's involved in the criminal legal system. But yes, I agree with Peter. Thanks. Needs work group.
I think one of the things that I'm looking for here is, does the three-pillar recidivism framework seem to generally work, and whether it should be supported or investigated, and whether it's helpful to our aims. So, other questions, thoughts, comments?
I'm in the room with you.
Oh, I didn't see your hand. Thank you. Please go ahead, Tasha.
Your definition for pillar one, your definition is just booking into the Whatcom County Jail. And I realize because we're looking at jail utilization, but I don't think it really captures recidivism if you're not looking at new charging, because we can do a lot of citations. We've had to, because we've not had room in the jail. And when your rationale is reflecting immediate system contact, you're not capturing citations for theft, driving while suspended, minor assaults that don't meet the definition of who we can book into jail. And so you're going to not capture maybe some behavior that is indicating that they're spiraling or they're not doing well, even if they're in one of the other, maybe they're using some pretrial releases. So you're not going to capture some stuff and maybe get behind the ball versus ahead of it. So I think under recidivism, I wouldn't just put booking. I would be looking at charges. And I know that under the sharing of information, the health department has access to Bellingham Police and the sheriff's office for information, but not any of the other smaller municipalities. And so I think people that commit crimes in the county and the Bellingham also come to Linden and Ferndale. So I think that's an area that we're missing that should be reflected in this as well.
Great, thank you, Tasha. Birdie, please go ahead.
Yeah.
Okay. There we go.
I think in the end, when we use the term recidivism, we're going to have to use it specifically for different purposes. it's kind of for the sake of what are we measuring this? And if we're measuring use of jail, then something like bookings is appropriate. If we're measuring, quote, rehab, are we people who touch the justice system? Are we successful in getting them never to touch the justice system again? Then something like Tasha's recommendation would be most appropriate. If we're looking at substance abuse, are we talking about, are they successfully, quote, clean forever, or are they relapsing in substance abuse, but not relapsing into the justice system? So I think this is a very important discussion. And in the long run, the specificity of what we're measuring is going to be what's important. And Caleb, I don't believe you're here today, but I've had discussions with him in the index committee that, if somebody fails to appear for warrant, is that the same as committing a new crime? And do you want to lump them all together, or do you want to separate them? And so, for the sake of using our data to improve quality and to come up with solutions, I suspect we're going to need much more specific measures.
I would like to point out that Caleb sent me, and I may have passed it on to you, Bertie. I cannot remember.
You did, but
Work that he is work, no, detailed work that he has done on this very topic. It's kind of like the next level of detail below this general framework, and
exactly.
so a lot of good thought from Chief Erickson has gone into the subject of recidivism. I would like to point out that in this, I'm not really addressing timelines, which is obviously a very critical aspect to measuring recidivism. Does a new charge or conviction come up within a 1 month period, 1 year period, a 3 year period, and that will be certainly very important for us to discuss. Wendy, please go ahead.
Just a couple of things that may be part of this discussion. Oftentimes, when you're looking at academic research that's been done or through like the Bureau of Justice Statistics, they do it on an annual basis because that's a good solid measure. And one of the things back when I was chief, because I'm a bit of a nerd, that I worked with IT to get some data. And one of the things that I did was ask that the IT department pull out individuals who had within a calendar year been booked more than one time. And what quickly became evident is that somebody coming into custody twice really was kind of like nothing, because somebody would have been arrested, say on a DUI. So they were arrested for DUI. One night they spent a certain amount of time in jail till they were sober enough to release. Then they go and get adjudicated. Then they have to come in and finish the 24-hour period, which is mandatory if you've got convicted of a DUI. So we kind of took that out, and I started looking at people who had been booked 3 times within a calendar year. And one of the things that I found out was, and I neglected to put the year, but it probably was 2023, maybe 2024. We had one offender who was booked into jail 13 times in a calendar year. Now that's an outlier, but the number of people that say we're booked in 3, 4, 5, and what you got was, it was like a bell curve. You had once you take out the 2 or less, you get here, and then it goes up here, and then it drops off into people who've been booked 13 times, 9 or 8. And oftentimes, just because I recognize so many of the names, that you can also do it across years. But years gives you a chunk, and it also gives you a way to start looking at if one group all of a sudden starts changing, we need to look why. Whether in Whatcom County we saw multiple arrests when fentanyl really started hitting the community. And it was because it was different than, and law enforcement knew what they were looking for. The hospital was dealing with it because I wound up talking with Dr. Everett up at St. Joe's. So the recidivism rate, if you use it on an annual basis, gives you an idea that something may be working or that something new has come into the community and we need to find out why. Part of that could be a change in the rules, as Judge Johnson was talking about, that on who's getting released and why. It can be a change in the number of felonies versus misdemeanors. And one of the other things that we run into is that it's not uncommon that when people come into custody, again, more than one or twice in a year, they have multiple charges. And that's where it can get confusing, especially for members of the public, because what you see is that so-and-so was arrested on first-degree assault on their partner. And that's the one that usually hits the newspaper and you hear about. But what you don't realize unless you go and look at that booking, that they've got 12 other offenses and have failed to show up. And so you get multiples. And that's where it can get confusing and kind of messy. Because then the attorneys and the courts need to work out what they're going to do with these other here, and what you get is that they get combined and written away. That the charges will be dismissed in return for the individual pleading out for the most serious one and wind up going to prison. The other reason that people would drop out of this data set that data set that we can look at recidivism, and all of a sudden somebody who is a high offender keeps coming in, disappears, then we go back, or then I would do is go back and look at the last time they were booked and what happened to them. And most of the time it's because they wind up getting sent to prison. And so then they're not coming into custody anymore because their body's over in whatever prison DOC has stuck them in. So it can be confusing. And the other thing that this kind of data does is if you can get the information to substance use folks or the mental health folks, that it alerts them, because what you'll find is that they're hitting those systems also. And so those are the people that come into custody a lot, but also need a combination of the other services that are out in the community. And it may be one way for the whole systems to say, here's an alert for us. We need to start following this person. They're newer to our community, but look at the amount of services they're getting to. And the jail can release information as that somebody's being booked, which would be an alert to those other systems. We need to look to see if this individual's in our systems, and if they're not, maybe they need to be. So trying to get those connections closer so that we don't have them just coming back into the jail over and over again and get stabilized for a period of time, and then they're released and here we go again. So I think that was it. I hope it makes sense, because it makes sense in my brain. It doesn't always come out that way though. So if there's any questions about anything I said, just let me know.
Thank you, Wendy. Appreciate that. It is a very complex, once you start diving into it, not only is there not just one measure for recidivism, but there are complexities within each of these pillars. What other comments or questions do people have on this subject? Heather, please go ahead.
Just leveling up a little bit. I think just stating maybe the obvious, our hope is to reduce recidivism, right? And what's really helpful about each of these pillars and definitions is that the policy intervention or the program or the process that we could change is different depending on which type of recidivism we're talking about and where it's happening. So I'm really excited to build on this, Peter. I'd love for a next step to be, it's so complex, I think, because we're talking about humans and all, and it's actually really quite connected to the conversation on Court Rule 3.2. And so I wonder about if we should be asking a committee to continue looking at what would be the highest leverage policy recommendations to make around these. What do you think, Peter? And what do you think, task force?
I'll speak to that. It would be great to come out of this meeting with some commitment from either committee chairs, interested committee chairs, or others who would like to work on tackling these definitions. And once we know who wants to do that, we can come up with some timelines and intentions and goals around that. Is there anyone on the call who is interested in taking this, volunteering to take this on and be part of this process?
Just a work group?
I would say, it might be a work group. It might be within a committee. Maya, please go ahead. Or you're just signaling your interest.
I am interested, yeah. But yeah.
Great.
I would be interested.
Okay. That's wonderful. And so we have Maya, Judge Jones, Birdie, we have Tasha. Are there others? Alexis, Dean, Raylene, Wendy. Oh, fantastic. Anyone else? Okay. That's great. There's really good representation among the people who have just volunteered across behavioral health and the criminal justice system. Is there good ones from each pillar group, is what you're saying? Yes, I believe so, from throughout all the pillars. So I guess the next question would be, is this a work group within the IPRTF? Meaning, does it report to us directly in this body, or is it within one of the committees? Heather, do you have an opinion on what would be most effective?
I have been really appreciating the work group opportunities and outcomes. I fully support that.
Mm-hmm. I'd like to propose that we make this. Dean, it looks like you've got an opinion on the matter.
Yeah, given the discussion a few minutes ago about the complexities of measurement of the results that we're seeking, I think this simply emphasizes the importance of the county bringing on a full-time person who can manage the development of the measures and the infrastructure and information systems that are needed to produce these measures. This is not work that can be easily accomplished by a work group or a committee who have other jobs and other responsibilities without the support of a full-time person. And so I guess I would just encourage that we ask the council to move forward on the recommendations that have been sent to them regarding the Village Reach recommendations.
Very good. That dovetails well with the recommendations of Village Reach and so many of the things that we have discussed within this group and Index and others. Alexis, do you have your hand up to add a comment?
I do, yeah. I hear Dean's recommendation, and that is some excellent insight. I'm also wondering how much of this would fit well within the reentry and diversion work group. I'm not seeing Brian on here, but Maya is on here. I know we've been looking at some different direction and some definitions within that. I know there's a lot of different entities involved in it, but just kind of looking at what we already have and expanding on it, I'm curious what that might look like.
Thank you. Raylene, go ahead.
Thank you. On the reentry, I know there's a subcommittee on that. I recently saw a presentation from the Administration Office of the Courts that talked about community resource centers, and they have converted their self-help centers essentially to include reentry and navigation. They had a presentation from Franklin County in state of Ohio on how they were implementing that. I just want to throw that out there so I don't forget about it, because it seemed to be very helpful in including that with reentry and making sure that there was sufficient navigation from jail release on reentry. Thanks.
Thank you, Raylene.
All right. I don't have I don't have an answer here, but what I do hear is that we have interested parties who would like to work on tackling this problem. I hear that, or this definition. I also hear from Dean that we should move forward with a recommendation to the council and to the executive that we have an FTE or an employee of the county dedicated to working on this. I would like to propose that we move on to now that we know who is interested in this, that we've had some discussion around it. I'd like to give it some thought and then get a meeting together and figure out what the best way forward is. Heather, any thoughts?
I think I support what you just said.
Okay.
Yeah.
All right, sounds good. Well, why don't we will move on from the subject today. Those who volunteered, please look forward to hearing from me, and we'll move something forward. Thanks so much for the conversation. It looks like the next item is the meeting calendar for 2026. Oh, there it is on the screen. Fantastic. This was in your packet. I don't know. I think what we're trying to do here is to approve these dates for the task force for the coming year. And Jill, do we need a vote on that, or is this just something that we can move forward unless there's objections?
The task force has traditionally voted on its annual calendar every year in December. So it's up to the task force. If they don't feel the need to do that by vote, then that's okay.
Does anyone have any significant issues with this calendar? I'd just like to move it forward. I think that
usually take a month off in summer.
Let's see. Jill, did we take August off? Oh, Scott, you've got a question. Please
Well,
go ahead.
I think this meeting meets every 4 weeks. And so that makes it a different part of the month every month. I was wondering if we could settle in on like the second or third or fourth, something Monday of every month instead of every 4 weeks, because then it aligns with other calendars that do things instead of every 4 weeks, they do it, once a month. But I'm fine with this. It just moves around, and then sometimes it conflicts with something and sometimes it doesn't.
Sure, Mayor Korheis, thank you for noticing that. Yes, it does. We don't settle on a particular Monday of the month, and the reason is because I have been asked to try and work around the Bellingham City Council meeting calendar every year. So they set their meeting dates up, and then I do my very best to try to schedule task force meetings on those off days. And those do change as well. So
I can live with what we got. I just thought it would be helpful to just do it a different way, but this is fine.
Thank you, Mayor Cortez. Marty, go ahead.
Yeah, I did hear somebody say something about summer recess. I just want to note that we're hoping to switch the J-pop summer recess to August, which would mean we'd have a July 16th meeting instead of an August meeting. So if we're approving the whole calendar plus committee dates, not just the IPRTF calendar, then that's one change. And then there is the question of whether this group would take August off as well.
In my experience, we have taken August off. And Jill, I believe that we're just approving the IPRTF calendar today, and we're leaving the approval of the subcommittee's calendar up to them. Is that correct?
that's correct. And traditionally, we've always scheduled an August meeting for the IPRTF. Sometimes it's canceled, sometimes it's not.
I am very comfortable with leaving it on the calendar and knowing that we're likely going to cancel it, but who knows, especially since we're building a jail and behavioral care center, there may well be a vote needed August 17th. Who knows? I would propose that we adopt this calendar as is. Any objections or discussion? Well, sticking with tradition, I guess, we should have a vote on this. Would somebody like to make a motion to adopt this calendar? I see Birdie has made the motion, and do we have a second? I see a second from Rosa, and any discussion? All right, all in favor, please raise your hand. Jill, let me know when we're ready.
I see all hands raised except for Judge Jones. And his hand is raised. I see this.
Okay.
Oh, and Maya. Thank you, everyone.
All right. Any opposed? I'm not seeing any opposed.
I see Maya and Raylene's hands are raised. Are you opposed? Nope. Okay. Thank you.
Okay. Any abstentions? And the calendar passes. Thank you very much, everybody.
Peter,
Heather, yes.
can I be just a human for a second and say I really support what Mayor Cortez suggested. I have sometimes I'm not all the way awake. The cadence does feel off sometimes, like the meetings feel like they come real quick sometimes or don't, and which is odd because it's every 4 weeks, and I know that scheduling conversations are the worst, let alone on Zoom with 35 people. And so I appreciate that we have a calendar. And if there is interest in thinking about, I'm sure we could find a third Monday or some regular cadence that honors the city of Bellingham's schedule. And I would be open to hosting that kind of conversation on the side and bringing something back, or just living with it, knowing that it's a big giant can of worms. But I just want to say that out loud, that I do appreciate that suggestion a lot.
Thank you for being a human. I appreciate that. Instead of our just moving through these items, yeah, I appreciate that. Thank you, Scott. And just a moment to say thank you so much for all of the time. We understand just how much time these meetings take and the subcommittees as well, and appreciate your being here on a Monday between 9 and 11. Heather, would you take the next item?
Yes, so this is we remember we're putting this on every agenda to just open the moment in case anyone has updates. Keeping our goals that we all agreed on are the most important things for us to work on front and center. So we have review our IPRTF priorities, goals, and action plan updates on the agenda. We have a list of 10 that are in the packet, but the top 3 that we agreed to work on together are best practices for design and operations of the new jail and behavioral care center, development of performance measurement plan and data dashboard to track progress on implementation plan projects, and strengthen and evaluate diversion programs to improve outcomes, reduce recidivism, and provide alternatives to incarceration. I think we've made pretty good progress and we continue to do so, but in order to keep advancing, we have to keep our goals front and center. And this is a chance for anyone who's working on those goals, whether as an individual contributor or a leader in our community or someone who runs a department that touches those goals, even inadvertently, or together on the task force. If you've made any progress or have news or information to share about any of those goals that's helpful for all of us across the system to know, now is the chance to share. I know Birdie's been doing quite a bit of work around data. You might want to share some of that on number 2. I don't know if there's any updates from the exec's office on number 1. Peter led a whole bunch of great work on goal number 1. And I think goal number 3 has been dispersed throughout the task force. And we're talking about how to formalize more measurement around diversion programs too. So I'll pause and look for hands if there's anyone who wants to share. Birdie, you're welcome to go first.
Well, the index committee met last month, and we chose as our 2 most important goals for the coming year. One is defining clearly the data fields that we would like to have on a public-facing dashboard. And of course, the discussion we had today on recidivism falls into that. And the second goal is to draw a more specific map of the quote infrastructure improvements that we need so that people in general know what we mean when we're talking about that.
Thank you. That's super helpful. Any other updates or news or questions? Marty, I see your hand.
I just want to make sure everybody knows that we're working on a what we're kind of calling an interim step, preliminary attempt to gather existing data that we could put forward for the community to see all in one place. And yeah, that's in process. It's not going to be a fancy dashboard, but it will be something that is an initial attempt to provide that kind of information. And we're aiming to have something up. If anybody has any data you want to share, we're collecting it now, and we're hoping to have something up in January.
Thank you, Marty.
Holly has a follow-up there.
Can I just say, Marty is doing such an amazing job of just being really systematic in gathering data, and that as we have been approaching people to ask for what they've got, people have been so gracious. So for everybody on this call who has already helped put stuff together, thank you so much. It's been just really great to have your support and investment in this whole process of making sure we've got the data available, and so we all know what it is, and at least put some of it up online. So thanks.
Heather, I see that Riley has his hand up. I'm not sure if he needs to be promoted or not, but
I would love to promote Riley and Brian for that matter. Right, if Jill could help Riley. speak.
There they
All right.
are.
I always appreciate getting promoted. Hi, everyone. Riley Sweeney with the County Executive's Office. I would just say that we're going to continue to invest in communicating about all the work that's being done to the community because this work only moves forward if the community is on board and understands what's going on and can be engaging in a positive way. I'd like to say that our Justice Project newsletter now has an open rate clearing 70%, which is, if you know anything about email marketing, fabulous. And we are getting lots of regular feedback and positive engagement. And so that's a priority for our office in 2026 to make sure that the Justice Project is truly a community effort, not just a community of those who know what's going on.
It's amazing. Thank you, Riley. The outreach has been pretty fantastic from the exec's office.
It really has.
And Marty and Holly, your work to just build that fundamental list of where is the data even living, I think is huge. And I think will really feed into and support Birdie's goals with Index. And so really excited about the opportunity for data. Okay. Want to move on to item 8, committee updates. Let's spend maybe, let's see, it's 10:35. Let's spend maybe 2 minutes per committee if there are committee updates. We can start with steering if Barry would like to share anything.
Yeah, I apologize. My camera has failed, and so I will just be on audio. We have covered basically everything that we did in steering at our last meeting, but we did have one topic that we kind of kicked off and started talking about, and that was the land acknowledgement. And Heather brought some things and shared that she had seen regarding land acknowledgement. So I'd like to just turn it over to her just for a little brief intro of this subject and kind of what the interest was by steering.
Yeah, the thing I'd like to share is that we only opened up the framing of the conversation because we really wanted to invite a few other people to have the actual robust conversation. But one thing that was clear even in the framing and the introduction of it at steering is that there is a real commitment and desire to pair meaningful action to closing disparities with any of the words that we say. And we want to make sure that the words we say are accurate and honoring and intentional and from the heart and don't become rote, and that they're really pulled out and looked at and paired with the actions across the criminal justice system. So I am hopeful about that opportunity and how we can build more intentional focus around that in 2026. And Rosa, I'm excited for your input and partnership on that work too. So you didn't miss much at that steering committee, and we purposely didn't go that deep. I pulled out a little bit of summary history that I did some research on. But it was really just an introduction to keep the conversation going. And in the new year, we'll have the full conversation. So there's still a chance if there's others who would like to join to do so.
Thanks, Heather. That was a very good conversation that we had to really kick this subject off. That's all from steering. So back to you.
Thank you. How about from Index? Birdie, you already gave us a slight briefing. Anything else you want to add, or you're good? Okay. Behavioral Health Committee. I know that the city of Bellingham had a big day, so we might have lost Dan. But if there's anyone else from Behavioral Health.
Behavioral health and legal and justice meet tomorrow, so there
Great.
won't be an update from them.
Anything that, Raylene, you're most looking forward to talking about tomorrow on your agenda?
I don't have anything to comment on right now. Thank you.
Okay. Okay. And then J-Pop. Anyone from J-Pop want to share any updates for the group?
We're going to be meeting on Thursday, and at our last meeting, We had a presentation from the Whatcom Racial Equity Commission presenting data on racial disparities in the jail population. And we're going to continue to talk about that at the coming meeting, focusing in on questions that need to be asked and then addressed to really dig into that topic with future analysis. And the other part of our meeting, major part of our meeting, will be focused on our 2026 action plan, which we've drafted. It's in the packet. We invite people to attend if you would like to sit in on that. We also can offer the planning, that kind of action plan design template if you would like that for your committees, and we can plug in things like meeting dates and stuff for you if you would like that. Yeah, just let us know.
That's awesome. Thank you, Marty. I think we all appreciate a template, especially coming from the solid brilliance of you and Holly. So yes. Conference room. You have a hand up. Anything you want to add?
Just want to add that the meeting on Thursday is in person. So if you could make it down, that would be fantastic. So we just get together. We've been trying to do at least twice a year in person, just so we know each other more than just on screens.
Talk about being human. That's a great idea. I'm glad you're doing that.
Well, and I think we should maybe borrow that idea and do that as the IPRTF a couple times too. So planting the seed.
Let's get a big room.
Sounds great. Okay. Let's move on to other business. This is a chance for any task force member to share anything on their mind that might be relevant to our business together. Great. One thing I'll just share briefly is there's a small planning group working on the update for the sequential intercept map, and there'll be a little request for information quasi application to attend coming out in the coming weeks. So keep your eyes out for that. And if you want to weigh in on designing that, give me a call. Designing the event, not the application. So Peter, I'll hand it to you.
Okay, great. Let's do public comment. Oh, Jill, please go ahead.
Thank you. I just wanted to check in with Heather on that invitation you said was going out. If that's happening, please let me know. I'll need to issue a potential meeting quorum. Thank you.
Thank you. It will be in February, so we have some time to do that. Thank you.
All right, let's do public comment. Is there any member of the public or folks that are on the call that are not part of the IPRTF or members of the IPRTF who would like to say anything? All right, I do not see anything, and we are alone in the room, Tasha and I. So we will close the IPRTF Law and Justice Council meeting for December 15th, 2025. I thank you all for taking the time to be here. Really appreciate the forward movement that we have here, and look forward to seeing you in January and throughout the year 2026.